This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Today, we're talking about the end of the line, the discharge of contracts. And look, this isn't just dry legal theory. This is about knowing when a deal is officially over, when you can walk away from a broken promise, or what happens when some crazy, unexpected event just blows everything up. Let's get into it. So when we say discharging a contract, what we really mean is releasing everyone from their promises. Think of this map here as showing you all the possible exits. The best exit, obviously, is performance. That's when everyone does exactly what they promised. Simple. But contracts can also end by agreement, or if one party commits a really serious breach, or if an unforeseen event causes what we call frustration. We're going to walk through each of these routes. So here's our game plan. First, we'll nail down what discharge actually is. Then, we'll look at the simple, happy ways a contract can end. After that, we'll dive into the messy stuff. What happens when a promise is broken, and what the law does when something impossible happens. And of course, we'll test your knowledge with some exam-style questions before we do a final recap. Okay, first things first. Discharge is the legal term for when all the duties under a contract officially come to an end. Once a contract is discharged, everyone's off the hook. You're freed from your obligations. First, a contract can end by agreement, where both sides just mutually decide to call it a day and release each other. But the most common, the most straightforward way is through performance, where everybody just does exactly what they promised to do in the first place. Job done.
There are two ways a contract can ask you to perform. Strict, you promise a result, and qualified, you promise a level of effort or care. If you can understand this, then most breach or not questions become simple. Let's look at what each term means. Strict obligation means you guarantee a specific outcome. If the result doesn't happen, then that's a breach. For example, seller shall deliver 100 chairs by the 30th of June. If the 99 chairs are delivered on June 30th or 100 chairs are delivered on July 1st, then that's a breach. While qualified obligation means you promise to try to reach an outcome using a stated standard, often reasonable care and skill, or reasonable or best endeavors. If the result doesn't happen, it's only a breach if you fell below that standard. For example, seller will use reasonable endeavors to deliver chairs by the 30th of June. Now, if a seller reserves backup chairs and updates you promptly but delivery slips, then there's likely no breach as the seller acted reasonably. To spot the difference, look for hard words and numbers for strict obligation. Shall, must. By June 30th, £1,000 due on May 1st, time is of the essence. Look for softeners for qualified obligation, reasonable care and skill, reasonable best endeavors, as soon as reasonably possible, subject. A strict obligation is easier to prove. Just show the promised result didn't happen. Then there's a breach. A qualified obligation is harder to prove. You must show the other side fell below the promised standard of care and/or effort.
But, what if the performance is almost perfect, but not quite? This is where the law is pretty sensible. It has a doctrine called substantial performance. Imagine you order a custom-made suit for £1,000. It arrives, but it's missing a 5-pound button. Can you refuse to pay the whole £1,000? No way. This doctrine says you have to pay for the value you got, but you can knock off the cost of fixing that minor defect. So you'd pay $995. It's a really practical rule that stops people from using tiny flaws to get out of a whole deal. Okay, now for one of the less happy endings, breach of contract. This is what happens when one party, with no good excuse, just fails or refuses to do their side of the bargain. This is a huge, huge topic for the exam, so let's break it down really carefully. So for a breach to be serious enough to actually end a contract, it can't just be any minor slip-up. It has to be what we call a repudiatory breach. Now, the bar for this is really high. It means the failure to perform is so fundamental, so serious, that it basically rips the heart out of the contract. It deprives the innocent party of the main thing they were supposed to get. The key phrase to remember is it goes to the root of the contract. So how do we figure out if a breach goes to the root? We have to look at the type of term that was broken. And for the SQE, you absolutely must know the difference between a condition and a warranty. A condition is a major term, a core promise. Breaking a condition is a repudiatory breach. It gives you the right to terminate the whole contract and claim damages. A warranty, on the other hand, is a minor, less important term. If you break a warranty, you can only claim damages for any loss. You can't just end the contract. The deal has to go on. Let's make this real with a classic case, Bettini v. Guy. So an opera singer was hired for a whole series of shows. The contract said he had to be there for rehearsals beforehand. He got sick and missed a few rehearsals, but he was totally fine and ready for the main performances. The theater tried to cancel the entire contract. The court had to decide, were the rehearsals a condition or a warranty? They decided it was a warranty. The main purpose of the contract, the actual singing in the performances, could still happen. So the theater could sue for any damages caused by him missing rehearsals, but they couldn't fire him and end the contract. And this brings us to a super critical point. When a repudiatory breach happens, the contract doesn't just automatically explode. The innocent party gets a choice. They can either accept the breach, which kills the contract and lets them sue for damages, or they can affirm the contract. Basically, they decide to keep the contract going, but they can still sue for damages for the breach. This power of choice is absolutely key, and it's what separates breach from our next topic.
Right. Now, what happens when a contract ends, not because someone messed up, but because of some massive, unforeseen event that's completely beyond anyone's control? Well, this is where the doctrine of frustration comes in. It applies when something happens after the contract is made that makes performing it totally impossible, illegal, or just radically different from what everyone signed up for.
This is probably the most important distinction you need to remember for the exam. With a breach, someone is at fault, and the innocent party gets a choice. With frustration, no one is at fault and the contract ends automatically for both parties. The second that frustrating event happens, the contract is gone. There is no choice to make. The law just says it's over.
The classic example is the case of Taylor v. Caldwell. A promoter hired a music hall to put on some concerts, but before the first show, the hall accidentally burned to the ground. The promoter couldn't sue the hall owner for breach of contract because the very thing the contract was about, the hall itself, had been destroyed, and it wasn't anyone's fault. Performance was literally impossible. The contract was frustrated, and it ended automatically for both of them.
But be really careful here. The courts apply this doctrine very, very narrowly. Frustration is not an escape hatch just because a contract becomes more expensive or harder to do. That's just a bad bargain. It also won't apply if the event was basically your own fault. That's called self-induced frustration. And finally, it won't apply if the event was something you could have or should have seen coming. All right, you've absorbed the theory. Now let's see how it all works in practice. Time for a couple of quick-fire exam-style questions. Ready? Okay, question 1. A developer agrees to build 4 blocks of flats. Before they even start, they send a letter saying, actually, we're only going to build 2. What's the legal effect of that letter?
The correct answer is B. Here's why. When a party tells you in advance that they have no intention of performing a core part of the contract, and building all 4 blocks is definitely a core part, that is an anticipatory repudiatory breach. The key thing is, the investor doesn't have to wait around for the developer to actually fail. They get an immediate right to terminate the contract and sue for damages right then and there.
Okay, question 2. An events company hires a specific named vintage ship for a cruise. The day before the event, the ship is struck by lightning and sinks. What's the legal position now?
And the answer is B. The contract is frustrated. The magic words here are specific, named vintage ship. Since that unique, essential thing has been destroyed by a totally unforeseen event, and it's nobody's fault, performance has become impossible. It's just like the music hall in Taylor v. Caldwell. The contract just ends. Great work. Let's lock all of that knowledge in with a final rapid-fire revision checklist. These are the absolute must-know points for your exam. Okay, let's drill this. Contracts can end by performance, agreement, breach, or frustration. Remember, only a repudiatory breach, a breach of a core condition, gives you the right to terminate. And when that happens, the innocent party gets a choice. Frustration, on the other hand, is automatic. No one is at fault, and it ends the contract for everybody, instantly.
And don't forget, it's not an easy way out of a bad deal. And finally, I'll leave you with a question to think about. Now that you know the rules, which of these methods do you think businesses actually want for certainty? The clean finish of performance, the difficult choice that comes after a breach, or the sudden, chaotic end from frustration? The answer to that tells you an awful lot about why commercial contracts are written the way they are. Thanks for watching.